Hello, hello,
I hope you can hear me clearly.
everyone. Yes, we can hear you. Welcome to Real Men's Talk, where it is sizzling hot, interactive, and transforming. Welcome to another beautiful episode on Real Men's Talk, where we shall be having another interesting and educative conversation. If you're watching live, hashtag live. If you are watching the replay, hashtag replay. Remember to like the video, make your comment, and share with your friends and loved one. I want to believe they will thank you for doing this. And on this episode of Real Men's Talk, we are going to be looking at a topic today: family legal matters. Family legal matters. We are going to look at will and next of kin, testamentary capacity when there is no will. And in the studio, I have my co-hosts, Dr. Femi Samuel.
Good evening, viewers. Good evening, everyone.
And also with me in the studio is Mr. Olufemi Oluwaleri. Mr. Olufemi Oluwaleri. Good evening, sir.
Good evening, ma. Good evening, viewers. Happy weekend.
And we have a special guest in our midst today who is going to be diving and educating us on the topic of discussion today. We have Barrister Oni Wango Stevenson. Barrister Oni is a legal practitioner and arbitrator, managing partner at Options and Equity Chambers. She is a member of Nigeria Bar Association, that's the NBA, African Women Lawyers Association Nigeria, FIDA, Amnesty International, Re-Evaluation Counseling Communities Worldwide. She's also a member of BNI. She is the immediate past General Secretary, African Women Lawyers Association Nigeria. She is the area reference person of Re-Evaluation Counseling Community, the editorial board member of Black Liberation Journal, published in Seattle, Washington, D.C. She is a chairman, current electoral committee of NBA Ikeja branch and African Women Lawyers Association Nigeria. She is married to Kenneth Odushola Stevenson. She is a mother and an environmental activist. She loves reading, writing, and traveling. Welcome, Barrister Honey. Barrister Honey, you're welcome to Real Men's Talk.
Thank you so much. I really appreciate it. Good evening, everyone. It's really a great pleasure to be
Good
here
evening,
this
ma'am.
evening. I've been asked to speak on about 3 different items. So we shall begin with looking at will and next of kin. Hopefully, by the time we finish, we would have answered a couple of questions that I saw earlier this evening. And if we did not cover the field, then we'll take other questions you may have. Primarily, a will is a document by which a person makes dispositions of his personal property as well as real estate. And this is expected to take effect after his death. A person that makes a will is called a testator if it's a man, and a testatrix if it's a woman. And basically,
That's the network there. They're hoping for a better reception today for our network. She has been able to tell us what will is about. The will is the legal document that a person prepare before his death to prepare how his estate will be managed by the people that survived the person. And she also mentioned that the person that writes the will is the testator. So while we are waiting for her, maybe we should just continue on some certain question why some people don't want to write will. Ms. Oluwalere, why is it that some people don't want to write? Some people deliberately don't want to write will.
Well, thank you for that question. You discover that the noise about a will in the developing countries is so very, very low compared with advanced countries. As we are talking to you, there are many educated people who do not even know anything about will. So you discover the noise about will in our setting is not really too pronounced. And there are some educated people that even when you talk to concerning will, what some of them will tell you is that, do you want to kill me? I am not preparing to die now. So why are you talking of will? And that boils to the fact that many people don't really know much or knowing the importance of wills. And they believe even approaching lawyers is always limited to cases. And they tell you, since I don't have case, why do I have to go to lawyer? Why do I have to draft will? So that boils down to the level of our education. But when you talk about a will, it's not that the person will die, but definitely every one of us will die one day. And because we will die one day, then it is absolutely necessary to have a will. And you heard our legal luminary when she told us about who a testator or testatrix is. So the fact that you have a will does not mean such person who is telling you to do a will is just praying for you to die. But it's just telling you because it's something that's really very important. Because you discover that most of the time when people die, people fight over such person's properties. And the only way you can get out of all these problems is when you have a will, which you maybe you entrust to a particular person that you trust very well. Let me rest my case here. Thank you.
Okay. The network has put her out again. Dr. Samuel, let's say that concerning the issue of will, is there anyone too young to have a will?
Actually, there is not no one that is to have a will. Most especially in this part of the world where the life expectancy is low. I've seen young people that are wealthy, people that recently we lost a musician in Nigeria, 44 years old. It may be strange to some people to hear to know that such a 4-year-old man has a will, but at least it's necessary. Will, based on my knowledge, can be, I mean, you can rewrite your will over and over again, adjust it as many times as possible. Thank you.
Thank
The
you, sir.
barrister is back.
I think back, okay. Barrister Honey, okay, good. So you can go on, madam. You can go on, please. Barrister Honey, you can go on.
I think our network is delaying the relay of the
Can you hear me?
message.
Well, I know our network is loud and clear, but
Yes, we
it's
can hear you.
delaying. It's delayed
Can you hear
from
me?
your hand.
Can you hear me?
Yes.
Yeah, we can hear you clearly. Clearly. Barrister, we can hear you. No.
Then I also observe that sometimes with hairpiece, it could be delaying. Do you observe that too? Sometimes your net or your audio can be delayed when you're using audio assisted piece. Okay, I was going to ask Dr. Samuel that, okay, Mr. Oluwalere, that some people believe that it's only people that are rich that are supposed to write will. How true is that? It's rich people that should write will. What do I have that I want to write will?
Well, I align with you. Most of the impression people have is it is only those who are rich that should write with. That's the impression of some people. Some will also tell you that it is only the educated people that write with. And of course, it's you can see that if you look at it critically, most of those who are uneducated don't have a way. But to me, writing wills is not limited to a rich man, neither is it limited to educated person. Will ordinarily should be something that people should embrace. But the problem we have in this world is that, or in this country, is that most of us, we are not really being enlightened about the issue of will. And as a result, we don't attach so much importance to it. And that's why you see most of the time when people die, a lot of people go into war as regards such person's property. And when you see what happens thereafter, you now discover that it is absolutely important or necessary to have a will. But be that as it may, many people believe that they don't see themselves dying now. And that it is only somebody who wants to die that should write a will. And that maybe it is when you get old and when you know maybe the time is the time is tickling, that is when you write a will. But it's a mistake. Because death has no reference for age, tribe, sex, or color. No. Death could come anytime. But that impression has always been there that it's only the rich men that normally draft wills, and in some cases, uneducated ones. Thank you.
Thank you, sir.
I think the problem we have in this part, the problem in this part of the world is that do you really engage the services of lawyers? Do you have a personal lawyer? You don't. Do you have a personal physician? You don't. Because you believe you don't need one. We believe it's expensive. We believe it's out of reach. In fact, people give testimony in church that they are all the years they've lived a legal case or maybe have need to visit the hospital. Because we see that as if you are wasting your resources when you are making consultation to them. Service of a lawyer on very few occasions that only acquire 1 or 2 properties. Most of us don't even employ the service of a lawyer when we talking about a will. Because we believe that what do I have? I have to sit down, talk to somebody, pay to help me write my will. If a barrister only one is around, maybe we should allow her to talk to us.
She's around, but her screen is dark. Barrister Honey, can you hear us?
You haven't called me. Okay.
She's back. His network is amazing.
If it is Glow is very, very funny network.
She said
On the
she's
areas and
using.
some areas. So as I was saying, there are so many things that we don't really. When last, if I ask now, when last do you see a dentist? Maybe we've never even seen a dentist in our life. And studies have shown that people that see dentists irregularly, the risk of dying from unknown disease is low. But people should dentist once in a year, once in 6 months. When last you have your blood pressure checked? When last you see, it's just in our setting that things that we could do for ourselves, we push it to God. And there's a lot of things about ourselves that we tend to neglect. The culture, over the years that things are hard, you don't have money, it's a waste of resources. And what do you want to do? You want to look for the shortcut. And by passing through the shortcut, don't believe that you should see a lawyer. I think that everything boils down to the fact that in our society, that is what the societal belief. It takes years of enlightenment to make us see things differently from what we've been doing. Like uh, have a family doctor or personal physician that know your story or something like that. Thank you.
Thank you, sir. Mr. Oluwalere, what's the place of will in the days when there are no lawyers? Because I understand that even in those days, some people will call somebody to write something down and say, this is how I want. So how is it done in those days?
I should say in those days, it wasn't all that common. It wasn't all that common, particularly in this area of the world. It's not common, and most of the time people believe it is only the lawyers that can do it, since most of the time it involves court matters. So as a result of that, many people absolutely believe it should be a legally binding something, which in real sense should be the lawyer that will do it. But I think since our lawyer is back, I think she'll be able to tell us more about it, so that we won't really encroach much in our areas of discipline. Thank you.
All right, sir. Thank you, sir.
Oh my God.
Barrister Honey, back to you.
Yes. Okay.
Sorry about the network.
Oh yeah. I don't know if you got anything when I started. I don't know if you got anything, but I just defined
Yes,
will.
we got your definition of
got that.
what
Very
will
well.
is. We got you telling us who a
Okay.
testator is.
Very well. Okay. So basically there are two types of wills in Nigeria. You talk about will in Islamic form, then will in English form. The will in Islamic form doesn't have, a lot of formality. But the thing is that under that will, the person can only distribute 1/3 of his estate. The other 2/3 will be distributed according to Islamic rights. They have, ways they have said 2/3 of a person's estate should be distributed. So the person making his will under the Islamic laws will simply, can only dispose of 1/3 of his estate. And that, Islamic will that is practiced by Muslims is called wasiya. Wasiya. I'm not sure I'm pronouncing it well, but the Muslims here will, know how best to pronounce it. And so the English form is the one that is guided by the statutory authority. Okay, that is to say, the will must be executed in accordance with the requirements of a statute. In here, okay, we have Lagos law, for example. Section 4 of the Wills Law of Lagos State specifies, the things that the requirements that a document that is so-called a will must possess. The first one is that it must be in writing. The second one is that it must be signed by the testator or by somebody directed by the testator. And that signature will be in a place on that will that is clearly showing that the testator indicated to sign off his will at that point. Of course, anything else that will come after that will is signed will not be taken as fact, in fact, will not be noticed. Anything after the signature will not be taken as part of the will. The testator also, will acknowledge the signature, his signature in the presence of two witnesses. That is when he will do that signing, in the presence of two witnesses. The witnesses also will attest the signature of the testator. There should be at least two witnesses. Whereas the witnesses, the two of them, must be present at the same time when the testator executes, that is, signs his will. The witnesses can sign at different times without necessarily being together. But the witness will sign in the presence of the testator, the person making the will. The two of them, the two witnesses don't have to be together when that is done. So these are the requirements of a valid will. Okay? Then, of course, the question again is who can validly make a will? The law actually says that everybody can make a will. The law also goes ahead to provide that for you to make a will, like the Wills Law of Lagos, for example, it provides that you have to be 18 years and above. Under some laws, like Section 2, Section 11 of the Wills Act of 1837, and also Section 9 of the Wills Act and Section 6 of the Wills Law of 1958, they specify 21 years. Okay? So basically what it means is that an infant cannot make a will not have the capacity to make a will if you are below 18 years.
Okay, we can hear you. Go on, please.
I hope my network is not acting again.
Yes, we can hear you loud and clear.
Remember, I've said that the will must be in writing. However, the law makes some exceptions. And these exceptions, are when an oral will can be accepted. And that is when, I hope you can still hear me. Hello?
Loud and clear.
Yes.
Loud and clear.
Okay,
we're hearing you.
Okay, so when the oral will can be accepted, it's when it is being made by, say, somebody in active military service, a person in the Air Force, and probably he's in air, or seamen when they are on the sea. If something is happening, they can make an oral will. There has to be a clear evidence to show that they intended to make the will at that point. That is when an oral will. Remember, we have said that one of the attributes is that it must be in writing. But the law gives that exception to these categories of people I have just mentioned. They are the ones that can make an oral will. That's what we call non-creative will. And the law will recognize that. I'll give you an example. In Re Stable, the court accepted, where a statement made by a soldier at the front, where he said, if I stop a bullet, everything of mine will be yours. And the court accepted that that was a will validly made. Now let's talk about next of kin. The next of kin, we'll still talk more about will when we talk about where there is no will and testamentary capacity. We'll still talk more about will. But now let's talk about next of kin. Okay, simply put, the next of kin, is said to be the nearest blood relation to a person. The nearest blood relation to a person. The specifics about next of kin vary from jurisdiction to jurisdiction. However, let us note that a legally and properly executed will takes precedence over next of kin inheritance rights. In other words, once
I didn't get that,
the person
please.
has properly made a will, you cannot be said to come, you cannot be heard to come and say, but I am the next of kin. He has put me down somewhere as next of kin, and this will has not reflected anything for me. You cannot be heard to say so. Because the will, once it is validly made, supersedes the once a will is validly made, it supersedes any inheritance of a so-called any inheritance rights of a so-called next of kin. Did you get that now? Did you get
Yes.
that? Or is my neck acting up?
Yes. Yes, ma'am.
In other words, let me give you a scenario. It is usually, we fill a lot of forms and they'll say next of kin, and you write someone as next of kin. All right. Now, the same person who wrote next of kin now happens to have made a will. Whatever he has in his will supersede any claims a next of kin wants to make. Do we understand that bit?
Yes,
Let me
yes,
know
we.
That's clear, ma'am.
Okay, very well. Okay, so that's the point I'm trying to make. That a legally and properly executed will covering inheritable property usually takes precedence.
Over talking.
Inheritance rights. That's just what I'm trying to say. But remember that we have said is the, nearest blood relation. But the law also provides that a spouse can be a next of kin. When we say spouse, now we're talking about say husband or wife. In other words, that means now that next of kin can also not be somebody that is bloodly, related by blood. So it can be somebody who is legally related by marriage. So you can have your spouse as the next of kin. I hope we get that. But let me also say there are some things that even if you write next of kin, that person cannot take anything from it because there are some provisions already associated with such things. For example, insurance policies and at times retirement benefits. At times when these funds are being filled, there are statutorily people who should take such benefits. So even if you write a next of kin, but that person, that so-called next of kin you have written, is not recognized by that insurance policy.
If I could get
Seems to
what
be
she was
having
saying,
a
she
lot
was
of.
trying to say network issue. I was trying to say that next of kin does not supersede a properly executed will. That means if you make a will, you can't knock off that will based on next of kin. That's well taken.
Yeah.
Can you hear me?
Clearly, man, clearly.
Yes, loud and clear.
Wow.
We are hearing you, man.
Can anyone hear me?
Yes, we are.
We can
Can
hear
you
you,
hear
man.
me?
Loud and clear. Loud and clear.
Network is very poor. I'm so sorry.
No, it's not
Well,
your making.
yeah. Okay, very well. So I think I'm not sure
You
again where I
stop,
stopped,
you
but
stop
let me
at
add
where
that.
we talk
Okay,
about next of
okay. I
kin
said
and insurance
very well.
benefits.
There's some documents like insurance policy. Okay, like insurance policies or retirement documents. In some establishments they have standards. Hello?
We can
We are
hear
hearing
you.
you, man.
Hello?
Yes, I can hear you.
Hello?
Yes,
Can
loud
you hear
and
me?
clear, ma. Loud and clear. Yes.
About what?
We can hear you.
We
You
can
can
hear
go
you.
on,
We
madam.
can hear you,
Okay,
ma.
apparently you stopped hearing me much earlier really than I thought. Because the
The area I
Network is.
really want a clarification before she come back online is that next of, because we know that when you are filling some forms as next of kings, in case of eventualities, maybe if you are filling insurance policy, all those things, your next of kin will be contacted and he has access to collecting those funds. I am aware that there was this, I think it's back, there was this particular doctor we lost, and the insurance cover, we had to pay the father who is the next of kin. The mother wanted to lay claim to the money because the parents are separated. It was the father that got the check for the insurance, for life insurance, not the mother.
can you hear me?
So,
Yes,
Yes.
ma'am.
yes, loud and
Mr.
clear. We can hear you now.
Then please, I would like you to clarify the difference between next of kin and beneficiary, because in some form, even in some bank form or account opening, you have a place for next of kin. Then you have another provision for you to fill in your beneficiary. So please clarify the difference between next of kin and beneficiary.
So what we've been doing is that whenever we want to retrieve funds for the insurance company, usually give it to the next of kin. But now she made it clear to us that properly executed will take precedence over next of kin. That for the fact that someone is in next of kin doesn't make the person taking a lion's share of beneficiary of your wealth. So properly executed will take precedence over next. She's back. Let me add that to the group.
I think, can I come in?
Please, sir, go on.
Can I,
Yes, sir.
can I come in?
Yes.
Next, to the best of my knowledge, next of kin is only effective if there is no way, just like she has said.
Can you hear me?
Once there is a way, I think that one takes precedence over the issue of next of kin. If I may get her clearly, since she
I
is
also
back,
think
I
that
think she.
depends on
She's
the
back.
law that is being executed. She's back. Now let's listen to her.
Okay. I was asking
You have
that there are some forms they are giving. You have next of kin and you have beneficiary. So what's the difference between both when you have both in a particular document? Marisa Honey, you can go on.
Okay. Do you want me to answer that question you asked?
Yes, you can go on
So
and
maybe
also
you finish
clarify
your
that.
presentation. Maybe after your presentation, you can ask her.
Okay,
because I
very
have
well.
questions to
All right,
ask
I think we've talked about. Okay, very well. Okay, I think I've told you that next of kin inheritance will not take precedence over a disposition validly made in a will. I've said that.
Ye-
Okay, but let me
Yes,
tell
yes.
you where next of kin, relationship is helpful, and that is when, it helps to determine inheritance rights where a person failed, dies without making a will, and has no spouse and or children. At that point in time, the next of kin can step in. I hope you can still hear me. There could also be some
Yes, loud and
responsibilities the
clear.
next of kin,
Loud and clear, madam.
takes up during the lifetime or after the death of the person. Lifetime, for example, if a person is incapacitated, medically and cannot take some decisions about his health, the next of kin can take a decision. Let's give an example of, say, somebody is going to go for a surgery. You know, somebody will sign off. So for the doctors at times will ask for somebody to sign that, okay, they can proceed with that surgery. If the person who has a next of kin is unable to do that, he can step in to give that authority. So the next of kin can also perform that duty during the lifetime.
So she was saying that the next of kin can take decision for the person while the person is alive. There's some certain decision. I think Dr. Samuel should be able to say something about that, about decision making for somebody that is alive. Maybe the person is now a patient. Dr. Samuel, can you throw more light on that?
Yes. We usually ask for next of kin whenever we are attending to a patient. And most of the time, when the patient is unable to make decisions, like a patient that is unconscious or so, we want someone else who is the next of kin to take decision. They have to be the person to sign, to give us the consent for the surgery. So in a hospital form, there is a place for next of kin. In case this person is no more, we need to do autopsy or organ harvest. Who is the next person that we should talk to that will give us the permission? The next of kin will be the one to do that. Also, the next of kin, in case of death, will be the one to be handed over to request or to collect the death certificate. Because these days, people use death certificate for a lot of things to access your account. So it's only the next now that has the power to come to the hospital that will be able to get the certificate directly from the hospital, can use it for any legal transaction. We are with you, ma. We are with you. Barrister Oni.
Am I on again? This is terrible. Okay,
Yes,
this
you
is
can
just
hear
terrible.
You're back on the stream.
Okay, all right. Okay, I think I told you where the next of kin can play a role during the lifetime or at the death of somebody who did not write the will. I hope you got that bit.
Yes.
Did we get that bit before I was?
Clearly.
Can I get a response?
Yes.
Continue.
Did you get what I said about the duty? Okay, very well. So let's also say that where a deceased person left no. Okay, great. Okay. All right. So where a deceased person left no will, then the estate will pass on to the surviving spouse in nearly all the states. I hope we are together.
We are.
Yes, ma.
I said where the deceased person dies without a will, his estate normally will pass to the surviving spouse in nearly all the states in Nigeria. That is what the law has. But if the surviving spouse remarries,
This is an interesting part of it.
I think what she was trying to say, if I may get her clearly, is that where the person who make a will, or where someone dies without a will, her estate or whatsoever properties or assets she left behind automatically goes to the spouse, which in most instances is the next of kin.
Say that most of the time it goes to
the time
goes to the spouse.
Yes,
Most
that
of
is
the
when
time.
there is no
Not
way.
the next.
When there is no way. That is
But
When
when
the
because
there is
person will
no
sometimes
just
they are
way.
assume that the
dependent
husband.
parents. Sometimes they consider dependent parents. If you have dependent parents, they are also considered.
The first
She will talk to
person
us
that
now. Maybe she
goes.
just enter and start talking to us.
Uh-huh. I know the first person it goes to is the next of kin.
Start talk to.
That is where there is no way.
Okay.
Can anyone hear me? Can you hear me?
Yeah, we are hearing you, man.
Yes,
Yes,
ma. We can hear.
We're back online.
Can you hear me?
Loud
yes.
and clear.
Yes.
We can hear you, man.
Okay. Can you hear me?
Yes, yes, yes.
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 Can you
Oh.
try and do away with your your hairpiece? Maybe that might
Can you hear
help.
me?
We can hear you. Maybe
We can hear you.
can you try
Can
and
you
do
hear me,
away with
please?
your earpiece? That might help your audio. It's like your audio is delayed.
It's not.
We can hear you. You have not deactivated your hairpiece. You're muted. You're muted. We can't hear you because you are muted.
Can you hear me? I removed my.
Now yes, we can hear
No, can you hear me
even
now?
louder.
We can.
Louder. It's louder
Okay,
now.
I removed my earpiece. Okay.
Yes,
Let
you're
me
louder
quickly
now.
say, because I think I overheard some things that you were saying. Let me quickly say, like, I said, if the person dies without a will, in most of the states, the laws provide that the estate will go to the spouse, surviving spouse. But what will happen if there is no surviving spouse? Okay. The person who is next of kin will then inherit the estate where there is no spouse. But let me say clearly, there is an order of inheritance when there is no surviving spouse. And the order will be the direct offspring, and that's the children. That is the children. They will be the first people. Then the grandchildren. Then the great-grandchildren. In that order, that is how it will go. People that will inherit. These are the direct offspring when there is no surviving spouse. Okay, now, in some places, the legal status of stepchildren and adopted children, in some places, they vary from jurisdiction to jurisdiction. They won't go into that now. Then where the deceased person has no offspring, no children, no grandchildren, no great-grandchildren, then the inheritance will move upwards. That is the order. It will move to, say, collateral, the collateral, the first people will be the parents. Where there are no offsprings, the parents, if they are still alive, they would inherit. I hope you can hear me.
Yes,
Hello,
loud
can
and
you
clear.
hear me?
Yes, ma'am.
Loud and clear.
Yes,
Can you hear me?
Loud
Clearly.
and clear.
Am I talking to myself?
We are
can hear
hearing you,
you.
man.
Very well. So now, if the next people, if there are no parents, will now be people will call collateral heirs. These collateral heirs are the brothers, the nieces, and the nephews. I hope you understand. Let me just recap. The first will be the spouse to inherit. If the spouse is not there, then of course we begin to look at the next of kin. But don't forget that we said the next of kin is usually blood relations. Remember? So in the order of inheritance, it will be the direct offspring that will come first. That's the children, the grandchildren, and the great-grandchildren. After them will follow the parents. And if the parents are not there, then the collateral heirs. And these are the brothers, the nephews, the nieces and nephews. These are the collateral heirs. Okay, I hope we got that.
Yes.
Yes.
But there's one thing
Yes.
that has been happening. Normally, a next of kin, we have seen, can inherit, some of the relatives' digital assets and obligations. Digital assets and obligations, For example, like Microsoft, they have a way of, they can package everything. The next, the person, when the person was, signing up, they have indicated a next of kin. So everything about that digital asset will be packaged and sent to the next of kin, who is expected to maybe take over managing the digital assets, or they can also inform other people that, oh, this person has passed on, or close down, that digital asset, all this online stuff and everything, that can be done. The next of kin, Microsoft does that. Okay, so I think maybe we can take questions on this, one before we move on to another aspect. We talked about 3 areas. So we've just looked at, will and requirements for a valid will. Looked at next of kin. So if you want to take questions, or I can go ahead to talk about testamentary capacity.
Let's go to testamentary capacity. Let's go on. You can go on then.
Okay,
if you're able to look at those questions that you did not address, then we'll come back.
Okay, very well. So in terms of testamentary capacity, we will normally talk about, basic things that must be there before a person can validly make a will. All right? Okay. And the first thing is that he must have requisite age. He must have requisite age. He must have mental capacity. Mental capacity, very key. And there must not be, that's no undue influence. No undue influence. And also, it must be clear that he knows and understood, or that he knew and understood clearly the different parts of the will. So it must be shown that is looking at the will on the surface of it. You can say, yes, the person who has made this will clearly understood, everything about this will. Also showed knowledge that he knows about what is, the property he is disposing, and who is entitled to, to inherit. So that's when you look at the will, it will show clearly that, oh, the person making this will has a clear understanding of what he is doing. So now let's look at age capacity. We have talked about the person, okay? The person must not be an infant, must be 18 and above. We've talked about that, okay? Must be 18 and above. In some jurisdiction, it's 21 years. In Nigeria, it's 18 years. Okay, you must be that. And the intention is that infants cannot make a will. So if you are below 18, you are not expected to make a will. And I've also told you about the exceptions, the soldiers, the military, the Air Force people, and the sea people, seamen in active service. So not somebody who is at the camp. No, somebody who is in active service. And that's when we can have that. So the age capacity also covers them, just like we talked about oral will.
Okay.
So people who are underage and below 18 can make their will only if they are in those same categories. I hope we remember the same categories I pointed out when we are talking about oral will, those that can make oral will. Mental capacity, okay? This means that for a person to make a will, it must be shown that he's of clear and sound mind at the time he made that will. If he was
Oh, Dr. Samuel, can you talk about testamentary capacity in relationship with mental capacity? That's also a field, you're part of your field.
Yes, I saw that for the first time when I was doing my psychiatric testing and testamentary capacity. Capacity to make a will that is valid, knowing full well that person must be mentally sound, must not be under any, must be under, not must be under any influence, either drug or alcohol. Now, what they meant is that the person, he doesn't know what to say, it's on sound mind, not having any psychiatric problem. Some other people have said that if someone a will made towards the tail end, I want that to address that towards the tail end of life, the person having a chronic, as no doubt, the person taking care of the sick will get a larger good percentage of it. It is clear that when a man has terminal illness like cancer, the person that is taking care of you, you are prone to giving major things to the caregiver. Let's listen to her. She's back online. Ma.
Or you can just complete this issue of having a clear caregiver. How does it affect testamentary capacity? Maybe somebody, it can be influenced because at the time you were sick, there's a particular person that is taking care of you. You can just complete that before, conclude on that before she continues.
Some people believe that the will can be defeated when it's made either.
What? Sorry, was that for me?
Maybe for me, but I was talking about I came across testamentary capacity during my psychiatric training, and what was said was that to make a will that is valid, one must have good mental capacity. You can think clearly. You are not under any drug. You are not mentally sick. And some have said that in case of chronic illness, maybe cancer or end of care, the person taking if a will made at that time can be contested because the person taking care of you is going to have a good share of that will, of course. There's no way you will hear it. You're already biased. You're already influenced by the person taking care of you. Maybe we should talk about, maybe we should throw more light on. Tell us about testamentary capacity. I'm not a lawyer, and I don't intend to be one.
I think Madam can go on since he's back and for the sake of the network. Madam, you can go on.
Hello, Madam Ejim. Good to have you online. Somebody is saying hello. Say hello here. Madam Mabel Ejim. Okay. In the comment section.
So can we go on?
Yes.
Yes, please.
Okay, I said that, for you to make a will, you must have, sound mind and mental capacity for you to make a will. So it means that a lunatic or person who is mentally infirm cannot make a will. But there's an exception. If a person can be lunatic, but remember, there's something we call lucid moments. Something can happen within the time. If the person executed his will at a time when he had clear knowledge of what he is doing, and after that he became mentally incapacitated, that will be valid. But he cannot execute a will when he is mentally incapacitated. He cannot execute a will. So where a testator executed a will when he was insane and later he became sane, that will be invalid. I hope you understand this. Yes. When a testator was mentally incapacitated and he executed a will, then later he became sane, that will be invalid. But if he had executed a will when he was lucid, mentally okay, and then he became incapacitated mentally, the will be valid. I hope you understand the difference. I hope you understood it.
Yes, ma'am.
So a person's mental capacity is therefore determined at the time.
So who determines mental capacity? Is it the lawyer?
At the time of signing the will. That is when we think about it.
Okay.
It's a question of facts. It's a question of facts. And that is why at times, when a very elderly person is about to make a will, at times lawyers will bring a doctor in. Will bring a doctor in to be one of the witnesses. It is not as determined by medical doctors. It is facts that are made available as evidence. You know, somebody would come to say, at the time this person, at the time they said this will was executed, this person could not have executed this will because he was not mentally okay. And they can bring evidence to show that, look, at the time they say this person executed this will, he didn't even know, he was almost in coma. He didn't know what he was doing anymore. He was delirious. Medical doctors who were attending to him can be witnesses who would come to say that, look, at so and so date, this person was in our care and was completely down. So it will be facts established. It's evidence. That's why you come to give hard evidence in the court. When you allege that the person was not mentally sound. So it is not as Dr. Wu. Remember, we have said it is at the point when he signed that document. What was the state of what was his state of health? What was the mental capacity of the person at the point when he executed the will? So it will be facts that will determine. So a person's mental capacity is determined at the time and date of the execution of the will. So the court will rely on medical evidence showing or providing the testator's mental capacity to reach a judgment. I hope you can hear me on the legal and not medical definition of mental capacity. The court will rely on the evidence presented about his medical records, the mental capacity at the time, medically presented. There are people who were around at the time this person, when they are claiming that this person signed the will. Okay, let me give you a clear example of a matter that we had in court. I personally was on that matter. This person claimed that the testator signed the will 2 days or on a certain day, and that was 2 days before his death. And there were records to show by doctors who attended to him on that day that he was so delirious. He didn't even know himself. He was in such pain. He was in such pain. He didn't know himself. He didn't know the people who were around. And that was when these people said that he signed the will. Unfortunately, too, even the signature of this person was at variance. But let's not go there. But the point was that this matter was at the criminal court. We haven't even gone to the civil court now to invalidate. By the time we pushed all this, that the person could, and the doctor's certificate, the doctors that treated him on that day, they said he signed the will. The thing was so overwhelming that they were now trying for this matter to be settled, because it was very clear that if it continued, even the lawyer that handled that matter would have a serious case. I mean, because it was a criminal aspect first. because the signature also was clearly forged. And it was subjected to forensic verification by experts.
Analysis.
In any case, like I said, basically it was by the time these things were put forth and the medical records were showing that this person was in a very bad state of health. There is no way he would have had the mental capacity at that time to execute that will. So at this point in time, they were now looking for ways to get this matter out from the criminal court. So what I'm trying to say is that it is the evidence that will be adduced, facts. The court will work on facts, not about the fact that somebody said, oh, he was not. No. Facts surrounding for evidence. To show that this person was not in a good state of health, mental capacity to sign that document. I hope this one is very clear. If it's clear, we can move on. Hello?
Yeah, it's very clear, very clear.
Okay, very well. So I've tried to explain what the court will rely on in arriving at that. Because at times it's like, oh, who would determine that the person is not, lacks mental capacity? I've tried to explain tenuously that it has to do with the facts that will be adduced in court, the evidence that we provided to show that on the very day, remember we have said it has to do with the time the will was executed, the person signed. What is his mental capacity? What is his state of health? Did he have the mental capacity to sign, to execute that will at that time? Not whatever was happening before or what happened after, but at the point where he executed the will, what was his mental capacity? And it is a question of facts. You must come to court and adduce the facts. And the judge will see clearly from the facts you will adduce before the court that
Barrister Oni, are you still there? Are you still there? Barrister Honey, are you still there? I'm not sure. Oh, I think our side is frozen. It's frozen. I didn't hear some of the things she mentioned. I don't know if you were able to hear. I was also put out. Dr. Samuel, did you hear some of the things she highlighted? Ms. Oluwalere, did you hear her? I was booted out.
Yes, we did. I think he was trying to explain situations whereby the testamentary document was forged at the point of the person who initiated the will, and that they looked at it, the lawyer and the person who was supposed to administer the will. There were evidences that at that point it was not really in tune with it, and that they forged everything, and that case was still in the criminal court, and they were trying to get out of it. That was where she was discussing at that point that it was proved that was there was a kind of criminal intention. That was what was discussing when you were booted out.
She's
and
back.
I think she's back. Yeah.
Okay. Well, I hope we got that when we are covering questions, anything that was missed. But let's talk about blind persons and illiterate persons. Remember that we have talked about the fact that a will must be in writing. So you might want to know, what about a blind person? Can he make a will? What about an illiterate person who cannot sign? Can he make a will? Yes, blind persons can make their will. What they have to do is to brief a lawyer. Brief a lawyer, that, and then the lawyer prepares the will. Okay, so when they give instruction, then the contents of the will will be read out to the blind person, and he has to know that yes, this is actually what I said. These are the things. So he has to confirm that yes, and it must be read to him in a language he understands. Very important. Okay. Then he can sign by a mark, just like an illiterate person. He can sign by making a mark or from printing, and that is accepted. I hope we are clear with that. So both blind persons are there. And then it's also very important, something we call jurat. When the will must show, it must clearly show that yes, this person could not read or write, but is aware that this is happening. It must be very clear. So it will be included and reflected in the will. Otherwise, it will be taken that the person didn't know what he was doing. So this, we call it jurat. So it must indicate this person, maybe he's a blind person or cannot read or write. So he's doing the thumb printing or he's doing just a mark. He makes a mark, but it must be very, very clear. Also reflected in the will that this was what happened. Otherwise, it will be taken that that person did not know what he was doing. Okay. So we've also talked about knowledge and approval. Remember, we are talking about capacity to make this will. So knowledge and approval, a will on the face of it, like I said earlier, will be taken that it's very okay. The contents of a will must be known to the person who is making the will. Let me give an example. There are times, there are people that ordinarily are expected to inherit from you. Let's say a child. There are times somebody will say, no, I'm not going to give something to my child. But he will state clearly the reasons why he's saying this person who ordinarily will inherit from me, the world will expect that he will inherit from me. But he can give reasons. You have heard of people who will say they have disowned this child or this, that, or whatever. But you must give clear reasons. So in the will, it also reflects that, that knowledge that he knows that ordinarily this person is supposed to inherit, but for some reason, I am not giving the person. And
that's exclusion.
So that's the way of showing knowledge. There are times some people will come when you are, challenging a will. They will say, ordinarily, you can know that this child is supposed to inherit from him, but to show that this person didn't know what he was doing, that this is not even reflected. So showing knowledge is to show clearly that that is very clear of what the person was doing. And the blind person or the illiterate, everything will be read to the person, and he knows. And there even are times when somebody cannot really sign. The person can give a clear instruction to somebody to sign is allowed, and he will be there. But it will also be clearly indicated that this person cannot do this, but ask this person to do it on his behalf. Okay. It must be very clear, because little things can, doing a will, preparing a will is very technical. Very technical. That's why you don't just go to anybody. A lawyer has to draw up a will for you because it's very technical. And you must make sure that as much as possible, everything that would allow for this will to become contested or become invalid, you must make sure you take care of all these things. And you have to have clear knowledge, clear understanding of the requirements, of the things that can easily make a will invalid. So that's why you don't just go to anybody to draw up a will for you. Go to a lawyer to do it. People don't like to spend money, but you need to get a lawyer to help you put together, a will that will stand, and not easily succumb to when it is being contested. And one thing again is that a will, most of the time, somebody who is a witness to the will, the law does not expect him or his spouse, for example, to take benefit from that will. Because a will prepared by a person who substantially benefits from the will may become suspicious. You have prepared it, and then you are making substantial benefit.
Yeah.
It might become quite suspicious. Okay? So we're talking about knowledge. Let's talk about undue influence.
Okay.
If there's anything to suggest, okay, ordinarily, somebody who is close to someone can exert some undue influence on the person making a will. So if somebody comes to court to assert that, no, this person was unduly influenced to sign this will, if it is proven, it's a ground to invalidate the will. So there must not be anything like undue influence when the person is preparing the will. Okay. For example, there was a case where somebody made his will on his deathbed, and his wife helped him to hold his hand as he signed the will. It was held that there was undue influence, and that will was invalidated. There was also another, at times when you are accusing that there is undue influence, you must provide facts. You can't just come and say undue influence. You must back it up with facts. Otherwise, it will not work. You cannot say, oh, I know this person is related and he was there when he's making the will. You must show clear facts. And one example is the one I just told you about, somebody who helped the husband to hold the hand for him to sign. It was held it cannot work. So there's another incident I want to, in Ree Harding. I will share with you what happened in that case. This lady, the husband had died, and then she started, consulting spiritualists, after the husband had died. Along the line, she met somebody who was a spiritualist. And this person was having sessions with her, doing whatever, however spiritualists do things anyway. Then eventually, the same spiritualist, influenced how the woman was very rich. The matter is called Ree Harding. Influenced how she obviously made the will. She made 2 wills, and in these 2 wills, this same spiritualist who was supposed to be, attending to her spiritual matters, took substantial benefits from the will. So when the matter came to court, the court said, no, that, from the evidence adduced, the court said, no, there was a clear intention of this spiritualist to manipulate the mind of the testatrix, the woman that made the will. So the court declared that will null and void. So that's against an evidence of undue influence. So in that matter, the court held that there was a clear evidence of undue influence on the part of the spiritualist, since it was obvious that he set out to take over the mind of his client, the woman, who made the will. So I've just been 2 clear examples for you to know that where there is undue influence, the court will say, no, this will cannot stand. For the same reason, when you are a witness to a will, and then your spouse, you yourself who is a witness, and then your spouse is also getting so much from the whatever, the court will say no, one suspect undue influence. So when you are writing the will, you must make sure you want to avoid all these things. Anything that would lead, you're trying to make sure that this document will speak for this person when the person is gone. Okay, so that's about testamentary capacity. Let's now go and look at what happens when there is no will. Let's quickly do that, and maybe we can now take any questions that would arise. So the point is that, remember, we have said the will allows you to, to distribute your estate how you want it done. That is one thing the will allows you. So, you you have a clear control as to how you want it to be done. Now, if you don't do that, then anybody, even your enemies, can have a way to come in. But when you have your will, you can distribute your estate, both your personal and real estate, however you want to dispose of it. So the best way for a person, therefore, is to dictate the way in which he wants his estate, his property, to be distributed and to be administered after his death, is to make a will. So a person that makes his will to dispose of his property in the way he likes, okay, by that way, it's saying that, look, you cannot modify my will. And even the court respects that. The court will not allow anyone to modify the will to suit what he is seeing as the imaginary intention of the testator. Leave it. The testator has made his will. Even the court will not interfere. The court will not interfere for you to come and adjust. Oh, let's adjust it because so and so is supposed to benefit, and so let's add it. The court will not listen to that.
It is valid.
You come and prove that if you are contesting the will, you come and prove that the will you give grounds based on which the will should be declared invalid. But the court will not, on the grounds that, I'm supposed to take benefits, I'm not there. Meanwhile, the man may have stated clearly, looking at the will, he's very sure of what he's doing, and he has said who he wants to get and who gets what. And then you come and say, no, I'm supposed to get more than he gave me. You are on your own. That will protect you, if you have done the will. So the position of the law is that a will should be allowed to speak in the way the person who made the will provided, and it must not be modified by anybody and not by court. So if a person dies and leaves a will, it is said that the person died testate. But if he does not leave any will, then it is said that he died intestate. And at that time, his estate will be subjected to the. I hope you can still hear me.
Yeah,
I said if he dies intestate, his estate will be distributed, according to provisions. But it will be immaterial at this time whether they meet his wishes or not. And that's why we are saying, make your will, otherwise anybody can take benefit. So there are two types of the rule of distribution which will apply when a person dies intestate. Two types of rules. And this will depend on whether the person was subject to customary law or statutory law during his lifetime. Okay. Then the estate of a person who dies intestate, that is to say he did not do a will, and he was subject to customary law, it will be distributed according to the native law and custom, okay, or Islamic law if he was a Muslim.
Okay.
Different traditions, they have their native law and custom. I know of the Bini in Edo, they talk about Idi, Igi, and there are basically two options, but we're not going into details. But the thing is that different jurisdictions, they have their law and custom, their native law and custom, by which, the estate of a person can be distributed. However, if a person who did not write his will is subject to statutory law, that is to say, he contracted a marriage under the Marriage Act, that is when we say he's subject to statutory law. So if that was what happened and he contracted his marriage under the Marriage Act, then his estate will be distributed according to the provisions of any local enactment, okay, relating to administration of estates. When we say local enactment, every state, like here in Lagos State, there is a law, administration of estate law, which provides of how the estate of a person who died without a will, how his estate will be distributed and administered. So if a person who is subject to statutory law, that is, the person married under the Marriage Act, then he dies without writing a will, then it follows that the law of the extant law in the state will guide how his estate will be distributed or and administered after his death. Lawyers know how these things are followed up because you have to obtain letters of administration. And at this point in time, he doesn't have the opportunity to appoint someone who will manage his whatever. So, but there are ways that one is done because he didn't write a will. But if he had written a will, he would have appointed the people that are in charge, of his estate. That is the benefits of doing that will. But because he didn't do that will, he won't have that opportunity. Yeah. So I'd like you to note that the law of a state is applicable to the deceased real estate. Yes. The law of the state where the real estate or the real property is located, that is the one that will be applicable to that. Okay. Let's say somebody died here in Lagos State. He has property in Edo State, for example. The law that will guide the distribution of that property in Edo State will be the law in Edo State. But his personal property and belongings can be guided, distributed according to the law of Lagos State where he resides, or his state of origin. Okay. Let's say now, if his state of origin is Edo, he has property in Edo State. He also has property in Lagos State, real property, real estate. The one in Lagos State will be governed by Lagos, the laws in Lagos, the laws of administration of estate in Lagos State. The property in Edo State will be governed by the extant law there in Edo State. However, his personal property, his personal belongings can be governed, whoever is now managing the estate, or whoever, they can elect that they would operate with the Lagos State laws, or they can decide, no, we want the laws of where he came from, that is Edo State. I hope you understand the difference. So what we are saying is that the deceased personal property can be governed by either his state of origin or state of residence. But the choice of the state at this time, will be made by the personal representatives, not by him, because he's dead and gone. He didn't make a will. If he made a will, in his will, he will decide what will happen to his property in this state, how he's giving it out and all that. But since he didn't make a will, it will not be subject to his personal representatives who will decide, the personal property, they can say, let's go back to Edo State and use the laws of Edo State to manage that, or Lagos State where he was residing. I hope we are very clear on that.
Very clear. Very clear.
Okay. I think this has come, this is the end of our presentation. We have covered the very three things, First of all, we looked at next of kin, and we looked at will and next of kin. And then we looked at testamentary capacity, and then we looked at when there is no will, what would happen to the estate of the person who died intestate, that is, died without a will. So thank you so much. The network has managed to allow us to finish this aspect.
Thank you so much, Barrister Honey. Such an informative session with you. I don't think we'll be able to attend to some of our questions. But before we go, I would like to ask Dr. Samuel and Mr. Oluwalere if they have one or two questions to ask you. Dr. Samuel, do you have any question for Barrister Honey? Mr. Ololere, you can come first, please.
Thank you very much, Barrister. You really whet our appetite this evening. And I know if we still give you 2-3 hours, I know you will still continue on and on and on and on like that. So we appreciate you very much, ma. My question is this. All these things will come up if there are people contesting the will. What happens if there is nobody contesting the will, and yet the will is full of some deceptions? What happened then? That's my first question. I don't know, did you get that question? Hello, man. Hello?
And the will is...
Hello?
The will is full of what?
I said, what happened if a will is drafted?
I want to say, and the will is not being contested, and yet it is full of what?
And it's full of maybe irregularities that could void the will. What happens if there's nobody contesting it, and it's full of irregularities? What happens for such a will? That's number one. The second question I will ask is, there have been instances whereby even a legal luminary made a will.
No, let me take that because of this
okay,
network.
Please do.
I think it should be safer.
Please do.
Hello.
Hello, man. I'm hearing you. Hello, man.
She's frozen. Okay, she's there.
Hello, man. I hope you get the question, man.
Well, I was saying, because of this network, let me answer the question.
Okay.
Okay, now.
Okay.
If you don't contest, if you suspect that there are irregularities, then you must contest the will. If you don't contest the will, like we normally say, I'm answering your first question. I got your first question. The law is not Father Christmas. If you don't come to court to ask for something, the court cannot give you anything. If you do not contest a will, then the will go. So if you feel that there are some irregularities, you must come forth to contest the will and then prove before the court with facts that this will should be declared invalid. Otherwise,
thank you, man.
The will pass probate.
So the silence will be taken for consent.
Thank you very much. The second one, man.
Your second question, you can ask it now. I didn't get it.
No, I've not really asked it. We've seen a situation whereby a legal luminary prepared a will, and I said we've seen a situation. Are you hearing me, man?
I didn't get the question.
I'm trying to frame it. I said we've seen a situation whereby a legal luminary who has passed on had a will before he died, and some of his children that are lawyers are contesting the will after his death. Could it be said that the will was not properly drafted?
No, it's breaking. Can you type? Is there any way you can type?
Oh, no way. Let me see. No, I don't really have it. Okay, I don't know whether it will go. But let me ask again whether you will get it. What could have happened when a legal luminary drafted a will, and after his death, some of his children that happens to be lawyers are contesting the will? What could have happened in such a situation? Did you get it, man?
I think I know. Thank you, Madam Edging. She said, thank you so much, Barrister Honey. Thank you so much for being part of the show. Um, so we hang on a little bit for her. And Dr. Samuel, do you have something to say, to add, while we're waiting for her to come back on the live stream?
Yes, I'm clear. I don't think I have anything to ask.
Okay, let's just hang on for her to come back so that we can round up. The network has really helped us to sap the time today, and the conversation is inexhaustible. We can actually attend to all the questions we have. Okay, she's back. You're back on stream.
What was the second question? I can quickly take that. Then maybe we come.
Okay, let me reframe it, ma.
Yes, let me take the second question. Please ask it. I didn't get it. It was I think I was.
Let me rephrase.
Just ask the second question. Please let me quickly take it before I get it.
Let me reframe it. I was trying to talk about the issue of Chief FRA. I was trying to talk about the issue of Chief Rotimi Williams, the late chief son, Chief Rotimi Williams. What could have happened after his death that his children were contesting his will? Do we say the will was not properly drafted, or what could have happened, ma? Thank you. Did you get the question, ma? Wow. Did you get the question, ma?
I think it's the late from my hand.
Okay, the will of Chief Williams. Where were they contesting the will?
Yes.
He knows the right thing to do.
Is that the question?
Yes.
Yeah.
Yeah.
Wow.
I mean, why were they contesting the will? Because it involves, it's more than even 1.5 hours. It's about 2 hours. I was trying to say what could have happened, because it was a legal luminary and those who are contesting it were lawyers. Do we now say the will was not properly drafted, or what could have happened? That was exactly my question.
There's always a loophole. There is a loophole in every law. So anybody can access that loophole to fault even the best of every process. Some people are just capitalizing on the fact that they can get a loophole to fault the process.
Okay, it's back.
Can you hear me?
Loud and clear.
Yes, we can hear you, ma'am.
Can you hear me?
Yes, yes.
Can you hear me?
Yes, we can.
Okay, quickly. It's about say people Chief Williams' will was being contested.
Yes.
And you are asking why? Is that your question?
Yeah. Yes.
There must be some. I don't know if that matter has been finally decided. On one of the days I was in court when that matter came up, there must be reasons why, and it was the children who were contesting.
Yes. Yes.
There must be reasons. They would have looked at it. I do not know exactly why they are contesting that will, but there must be some reasons. And the fact that they contested the will would not necessarily make the will invalid. Again, they would have to present facts before the court, depending on what allegations they are, what they are challenging. Whatever they are challenging, they have to back up with facts. And so if the court looks at the facts and they find good reason to believe that the grounds are good enough to render the will invalid, then the court will so declare. Anyone, the children, they have the right, they would have studied the will and said, no, there's a reason why I think this will is not validly made. They have to prove it with facts. I don't have exact details of why they are contesting that will, but it's on record that they were contesting the will of their father.
All right. Thank you so much, Barrister Oni. Do you have a final word take home for our viewers on the subject matter?
Okay, yes. Take home will be this. You don't have to, the will, it's not only rich people or people who have acquired so much property. Even the little you have, your personal property, you have labored and worked for it. It's okay for you to decide who gets it. So don't wait. Again, this fear about, writing a will mean that you're about to die. No, remember, death has no age limit. It doesn't know age. It can happen at any time. It is just that you are trying to take care of things when you still have the opportunity. So you want the will to speak. You want to have a voice even after you are gone. So there's no reason for you to feel that, to start feeling that, no, when I start thinking about making my will, maybe it's about, are you trying to die or are they going to kill you? No. So get a lawyer. That's my last word. Make a will so that you can have a voice even when you are gone. You decide how you dispose of all these things you are laboring and struggling and hustling. Decide who takes benefits. Decide who administers your estate when you are gone. And doing that also ensures that it is those people that you want to take benefit that will take benefit. And not that when you are gone, the things will be distributed according to statutory law or by, customary law or Islamic law, depending to whichever one you are subject to. So, meet your lawyer, talk with your lawyer. That was my last word, and don't be scared. It's okay to have your will put down, and you can keep reviewing your will as many times. There's what we call codicil.
How often can you review the will? What should be the interval? How often should that be?
You can do a will yesterday. No, nothing stops you. It's your will. If by tomorrow you think you want to change your mind, maybe Mr. A you've put as somebody to inherit, you think he doesn't deserve all this, you call your lawyer, you change, or you want to add some things. It's what we call codicil, which you can also add. Or you can even decide to destroy completely a will that you have done. You can destroy it and do another will. So the law does not specify how many times you can do your will.
Okay. Thank you so much, Barrister Oni Stevenson, for having you on Real Men Talk. It has been an informative conversation with you. It's a pity that the network wasn't friendly, and more so the topic is inexhaustible. We have so many questions we'll have loved to address, but because of the time frame, we will not be able to address those. So we are so glad, we are delighted to have you on Real Men Talk. Thank you so much, Barrister Stevenson.
Thank you so much. I really appreciate it. And thank you to Mabel, if you are still there. Thank you. I see your message.
Say thank you so much, Barrister. All right. Yeah, and we want to say a very big thank you to our viewers at home. I strongly believe that you have been informed, you have been enlightened about this topic. If you have any question, you can put it on the live stream, on the comment section, so that we can look at it. If you have any question regarding the topic of discussion, we can look at it. And if Barrister Stevenson she can find time to look at those questions and answer them. And on this note, we are going to say thank you, viewers, and everyone for being part of the program. And make sure that you share this with your friends, with your group and loved ones. I'm very sure